Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, and how we're going to fix this bad boy together. Right now, we're going to walk through the dissent from Justice Clarence Thomas, as I promised in the Ghost Guns case. You know, that one where we were just handed by the Supreme Court a 7-2 losing opinion against what can be considered a frame and receiver because the ATF decided ad hoc to redefine definitions and terms passed by Congress outside of their congressional authority. Yeah, that one. Well, Justice Thomas did exactly what the entire opinion should have been written by Gorsuch. This should have been the majority opinion. Everything I'm going to show you right now is linked in the description box below. Of course, make sure you hit that like button, subscribe to the channel, turn the notification bell on because per usual, Justice Clarence Thomas is spitting fire. All right. So as you guys know, this decision was 7-2. That means that all three of the Trump-appointed judges went against us on this one. You got Kavanaugh, ACB, or Amy Coney Barrett, and Gorsuch. All three appointed by Trump. All three said that no, the ATF can completely make up rules and redefine existing congressional statutes. Piece of cake. Alito and Thomas are the only people who dissented, and the only reason Alito dissented was because of technical approaches and language and different statutory tests, which I'm not even going to go into because it had nothing to do with the Second Amendment, to be quite candid. But let me go into this, because Thomas actually mentioned the Second Amendment, weird, and guns and stuff. It's odd. Let's get in here. I got a few highlighted points, because now I've got the PDF downloaded and I can actually give it to you. So, Justice Thomas dissenting. The government asked this court just last term to rewrite statutory text so that it could generate semi-automatic weapons as regulate semi-automatic weapons as machine guns in the Cargill decision. We declined to do so, so we won on the Cargill one, but now we've lost on the Vanderstock one, which is the frames and receivers. The government now asks us to rewrite statutory text so that it can regulate weapons parts kits. This time, the court obliges. I would not. The statutory terms frame and receiver do not cover the unfinished frames and receivers contained in weapons parts kits, and weapon parts kits themselves do not meet the statutory definition of firearm. That should end the case. The majority instead blesses the government's overreach based on a series of errors regarding both the standard of review and the interpretation of the statute. I respectfully dissent. He brings up a very interesting point in his introduction, and there's a lot more things here where he just spits fire, which I'm here for. But it brings up an interesting question. Do you remember the phrase, if it looks like a duck, it quacks like a duck, it is a duck? Yeah, that was said by Sotomayor in the Cargill decision. Well, they said that a bump stock wasn't a machine gun in the Cargill decision, as Thomas notes here. But all of a sudden, in the Vanderstock case, now it is a redefining of a term. Now it can be readily converted. So now it is something that it wasn't. It's an inconsistency. This is not a good opinion. Anyway, let's continue, because I got a few more highlighted points. I'm just going to jump around to them, but it's all linked. Thus, by defining frame or receiver as the parts of a gun that provide the housing, the hammer, the bolt, or the breech lock, and firing mechanism, ATF's initial definition fit neatly into a statutory scheme. This understanding of frame and receiver governed for about 50 years. Yeah, that's the whole point. The ATF made this up whole cloth by redefining terms inside existing law already passed by Congress, and then they made a new rule out of whole cloth because they redefined terms. By the way, if we're going down the road of you can ban anything that's going to be something, let's do abortion. Let's go. When is it a baby? When can it not be a baby? It's going to be a baby, so is it a baby? Yeah. Why don't we apply this bad boy to abortion and see how far the lefties freak out from the roofs? Anyway, let's continue. But the ATF recently changed course. In an effort to regulate so-called ghost guns, privately made firearms built from kits or collections of unfinished parts, to tackle what it perceived to be the homeland security threat posed by the wide availability of ghost guns, the agency promulgated a rule redefining firearm frame and receiver. Definition of frame or receiver and identification of firearms without any changes to the statute. The rule expanded the regulatory definition of firearm to include a weapon parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of the explosive. This is the problem. The ATF literally undermined 50 years of law because they wanted to redefine a definition. That is Congress's job to set terms and definitions. It is not the ATF through the executive bureaucracy's determination to make up new rules by changing a word that Congress clearly did not define as that word. That's the entire problem at hand here. The problem is not the ghost guns. The problem is not the frames and receivers. The problem is literally an executive bureaucratic agency just wrote a law by redefining a term and definition, giving a completely different outcome, holding the penalty of prison time. That's the problem. These executive bureaucracies are completely out of whack. Let's continue. Oh, sorry, I'll just do this quickly. I did that already. The ATF, however, they offered one meager limit on its broad new definitions. Under the rule, raw materials such as an unformed block of metal or liquid polymer will not constitute a regulable frame or receiver. You know, someone left a comment on my earlier video when I was saying and kind of break this down right when it came out and was released, that it was a bit of a far reach for me to say that, you know, that mountain over there has metal in it. Is that a firearm? There's no defined term of what readily convertible means. It's up to the ATF's own broad interpretations. If the director decides it's readily convertible, all of a sudden it's readily convertible. So the idea that it's not something, I don't know, at 30% or 10%, there is no defining characteristic. That's the whole point. I don't think I'm out of scope here to say that we need clearly defined definitions. In fact, right here, the ATF said, no, it's okay. Raw material and unformed blocks of metal aren't constituting firearms. Okay, well, what about when it's 10%, 5%, 1%? It's not unformed anymore. Do you see the problem? These things hold the penalty of law. Anyway. This is such a bad opinion. Let's continue. Got some more stuff. So in this case, the district court granted summary judgment to the plaintiffs and vacated the rule. The Fifth Circuit affirmed in relevant part. It held that the ATF's redefinition of frame or receiver was an impermissible extension of the statutory text, and that the agency's attempt to redefine firearm to include weapon parts kit stretched the statute's words too far. The government's effort to justify its unprecedented expansion of the Gun Control Act, the court explained, collapses upon a cursory reading of the text. Yes, but for some reason, 7 justices just decided that the ATF can completely make up rules whole cloth. Guys, this is extremely concerning. And we're about to get into the AR-15s being readily convertible into machine guns here in a second. Because even Thomas sees this coming. All right, let's keep going. Judge Oldham wrote separately to highlight the staggering implications of ATF's new position, particularly with respect to the AR-15, the most popular rifle in America. Observing that the rule regulates frames and receivers according to what they might become rather than what they are, and that an AR-15 semi-automatic receiver can readily be converted into a fully automatic receiver with relative ease, he concluded that on the ATF's logic, the government may regulate AR-15s as machine guns. I guarantee you, before my time on this earth is done, we will have this argument brought forward from gun controllers the next time they have power, that because AR-15s are readily convertible into machine guns, we should ban AR-15s. That is going to happen. Stamp it, mark it, timestamp it, because that's exactly what they wanted to do through this entire thing. And the Supreme Court just gave them carte blanche to do it. God. Let's continue. The ordinary meaning of frame or receiver does not include objects that may be converted into a frame or receiver. As the government itself admits, the word convert means to change into another form, substance, or state or product, transform, transmute. If an object can become a frame or receiver only after it is changed into another form, substance, state, or product, it is difficult to understand how the object can be considered a frame or receiver even before the change occurred. That's the entire point. It's going to be completely different, and then all of a sudden, magically, it's now something different, even though it didn't go under the words of transformation. All right, now let me show you how he wraps this thing up, because it's a well-written wrap-up. I would take Justice Scalia's approach here. Nothing in the Gun Control Act suggests that the terms frame or receiver also include the materials that one could use to create them, or that parts including neither a frame nor a receiver could constitute a weapon. There are, however, many reasons to conclude the opposite. Even the government appears to have found these competing interpretations persuasive just a few years ago. See this brief. Quote, now it says it's the opposite. The law hasn't changed, only on an agency's interpretation of it. I would apply the rule of lenity. That means basically say, get it out of here. Congress could have authorized the ATF to regulate any part of a firearm or any object readily converted into one, but it did not. I would adhere to the words Congress enacted. Well, that's a novel concept. Employing its novel artifact noun methodology, the majority charts a different course that invites unforeseeable consequences and offers no limiting principle. I respectfully dissent. Yes, that's exactly correct. It invites unforeseeable consequences, which is why we do not give executive agencies this broad-based authority. Even when the good guys control it, even when the bad guys control it, you don't give these executive bureaucracies this level of power. It's not good. It only sets the table for bad things to happen. 7-2 opinion. Thomas is the only one speaking any type of logic at all. And meanwhile, when addressing the AR-15s versus machine guns, the majority opinion here says, well, ATF hasn't done it before, so it's okay. Oh, this one really angers me. All right. That's all I've got for you guys. I hope you enjoyed the dissent, the review of said dissent, and I will see you on the next one where we continue grinding for freedom. See you all then.